or in contravention of this Constitution. Number 2, the question whether anything said to be done under the authority of the Constitution or under any law is inconsistent with or in contravention of this Constitution. Number 3, any matter relating to constitutional powers of the state. I'm going to read the introductory part and the analysis part. So on the 9th of October 2024, the advocates for the parties in petitions E522 of 2024, E509 of 2024, E537 of 2024, E528 of 2024, E524 of 2024, and E506 of 2024. Yes, appeared before me for directions in aforementioned matters which relate to the impeachment process of the Deputy President of the Republic of Kenya. The court allowed the advocate to submit with a view to assisting the court to fashion an appropriate directions to make in respect of the cases without delving into the substance of the application and the petition. As part of those submissions, 2 issues prominently featured: the empanelment of a bench to hear the petitions and an application to transmit the files to the principal judge of the High Court for consolidation of the matters. The petitioners who had made the application for empanelment were petitioner number in E509 of 2024 and the petitioner in E522 of 2024. Their applications for empanelment were vehemently opposed by the respondents. For context, it is necessary to indicate the petitioner in petition E509 of 2024 and who was represented by Mr. Degwanjiro, and in prayer 6 of the notice of motion dated 30th of September 2024 sought an order in the following terms, and I quote, that the matter be certified as raising weighty legal issues and the same be remitted to the Chief Justice for empanelment of an even number of judges for hearing and termination of the petition. In petition number E522 of 2024, the petitioner had similarly included the prayer in the notice of motion dated 2nd of October 2024 as follows: that upon inter partes hearing of the application or such other time as the court may determine, this honorable court be pleased to certify this matter raises questions of great general public interest for empanelment of a bench of an even number of judges for hearing and determination. End of quote. I will not go through the petitioner submissions which are in the ruling and also the submissions by the respondents, so I'll go straight to the analysis and determination part. From the submissions of the advocates herein, the 2 issues which arose was whether I should forward these files to the principal judge of the High Court based on section 6.1 of the High Court Organization and Administration Act, Cap 8C, Laws of Kenya, and number 2, whether I should certify this matter to the Chief Justice for empanelment of an even bench to hear and dispose these petitions. On the first issue, it is important that I set out the provisions of section 6.1 of the High Court Organization and Administration that the respondent cited as the basis of the application for this court to transmit these files to the principal judge so that it may be consolidated with others that they alleged are similar. Section 6 states as follows: the principal judge shall be responsible to the Chief Justice for the overall administration and management of the court. B, ensuring order and prompt conduct of business of the court. C, the constitution of benches of 2 or more judges in consultation with the Chief Justice. And D, undertaking such other duties as may be assigned by the Chief Justice. The above section that the respondent cited in urging that I should transmit the files before this court to the principal judge, based on allegation that there are other matters raising identical issues, is in my view inapplicable as it relates to general court administrative responsibilities bestowed on the principal judge, where the issue of consolidation is a pure discretionary function that rests on the particular judge and exercisable depending on the facts and circumstances of every case. This court is not persuaded that without the benefit of looking at those other files, this application is meritorious. This leaves me with the second issue, which is whether this court should certify this matter to the Chief Justice for empanelment of an even number of judges to hear and determine. Article 165, sub-article 4 of the Constitution makes provision for empanelment of a bench by providing thus: any matter certified by the court as raising substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice. Article 165, 3B or D of the Constitution has been delineated in Article 165.4 as constituting areas from which substantial questions of law might arise to require the composition of a bench. The two specific areas relate to the following. B, jurisdiction to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. And D, jurisdiction to hear any question respecting to the interpretation of this Constitution, including determination of whether the question of any law is inconsistent with or in contravention of this Constitution. Number 2, the question whether anything said to be done under the authority of the Constitution or under any law is inconsistent with or in contravention of this Constitution. Number 3, any matter relating to constitutional powers of the state organs in respect to county governments and any matter relating to constitutional relationship between levels of government. And number 4 is a question relating to conflict of laws under Article 91. The phrase substantial question of law is not defined in the Constitution. In the case of Harrison Kenyajui versus Attorney General 2012 EKR, the court stated as follows. A matter may raise complex issues of fact and law, but this does not necessarily imply that the matter is one that raises substantial issues of law. Judges are from time to time required to determine complex issues, yet one cannot argue that it means that every issue is one that raises substantial questions of law. Thus, there must be something more to the substantial question than mere novelty or complexity of the issue before the court. It may present unique facts not plainly covered by the controlling precedents. It may also involve important questions concerning the scope and the meaning of the decisions of the higher courts or the application of well-settled principles to the facts of a case. End of quote. Likewise, the court in Philomena Mbete Mwilu versus Director of Public Prosecution observed as follows. A question of law would be substantial question of law if it directly or indirectly affects the rights of the parties. There is some doubt or difference of opinion on the issues raised and that the issue is capable of generating different interpretations. If, however, the question has been well settled by the highest court or the general principles to be applied in determining the question before the court have been well settled, the mere application of those principles to a new set of facts presented in a case before the court would not on their own constitute substantial question of law. There must be possibility of a matter attracting different interpretations or opinion in its interpretation or application of principles espoused in the matter to make it a substantial question of law. All this notwithstanding, it is up to the individual judge to decide whether the matter raises a substantial question of law for purposes of reference. The court also dealt with that question in the case of Okia Mtata Okoiti versus Anne Waiguru, Cabinet Secretary, but I will not go through that now. It's a long excerpt. You may have to read it for yourself. I listened attentively at the issues in contention in these petitions as they were being canvassed by the party's advocates. On the issue of the constitutionality of standing orders, the respondents strongly oppose the contention that this amounts to substantial question of law because such issues have been litigated before, including constitutionality of statutes by single judge, and thus is not a novel question warranting the referral of this petition to the Chief Justice. I was, however, keen to pick out the unique challenges pointed by the petitioners in assailing the standing orders that the National Assembly particularly relied on in carrying out the impeachment process. The petitioners pinpointed various concerns. The limited duration of 7 days to carry out the entire process was cited as having an inhibiting effect on carrying out adequate and meaningful public participation.